Estate plans are not a one and done proposition. They need to be updated as circumstances in life change. You get a new job, you get new assets, people fall in and out of favor who are your beneficiaries. We've all talked about how to amend wills in the past, but what happens if you screw it up? Well, today we're going to look at the case of In Re Penniman, which I call the case of the Holographic Codicil. It's an 1874 case that is still actually good law today. However, it was based on the common law, and today we have statutes that have replaced the reliance on that case. We're going to look at In Re Pennimans and see what they decided, and then see how it would be decided under modern law today. Hello, my name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and greater Minnesota alike. If you like today's video, please feel free to hit that like and subscribe button. It actually really helps support the channel. Also, before we get going, two caveats, same as always. First of all, these videos are for educational purposes only. They are not giving legal advice. And second of all, we're going to be talking about Minnesota law specifically here. If you live in another jurisdiction, the law may be the same or similar, or the theories may translate, but make sure to talk to an estate planning professional that's licensed in your jurisdiction for your estate planning questions. Okay, so let's look at In Re Penniman and then see if the 1874 decision would be the same as if it was made today. So in this 1874 case, the facts are very simple. There was a probate of a will that had amateur changes. Things were crossed out, and then scribbles were written in between the margins to replace the things that were crossed out. In the end, there was a conflict. Somebody probably got less money due to the cross-outs and scribbles than they would have before that, so they challenged the will. The issue before the court was, did the crossing out and scribbles amend the will? Now, the court looked at this and applied the common law, and the judge determined that the handwritten notes were never notarized as parts of the will and were never witnessed, and therefore do not amend the will. In the 1874 law is still good now, but as often happens with the common law, it's been codified into statute in a various form or another. So if we did the case today, what would be the result? Would the judge still find that the will was not amended properly? Or would it be amended? Or would it be rescinded entirely? Well, to answer that, we've got to look at a couple concepts that we have under modern law that are codified under the statute. Concept one is the idea of a holographic codicil. A holographic will is a will that is handwritten. In some states, such as Colorado, for example, if you handwrite the essential portions of the will, sign and date it, then you don't need to have it notarized and you don't need to have it witnessed. Now, Minnesota does not allow this. Minnesota Statute 524.2-502 provides that execution of a will requires that there be two witnesses and it be acknowledged by a notary. And furthermore, if you're making an amendment to the will, you have to follow the same execution guidelines as required for executing a will in its entirety. Now, there is one exception where Minnesota will allow holographic wills, that is if you are in a state, if you reside in a state that authorizes holographic wills and you draft your will there in accordance with the statute and it's executed properly as a holographic will and then move to Minnesota, and Minnesota becomes your residence, Minnesota will honor a will drafted in another jurisdiction, even if it's a holographic will. Anyways, we cover holographic wills in detail in another video. The main point is Minnesota does not allow for holographic amendments or holographic codicils to wills. The second concept has to deal with what is required for rescinding a will. Minnesota Statute 524.2-507 requires one of two things to rescind a will. First, you can do a rescissionary clause, and if you've ever done multiple wills, you've probably seen this. It's a clause at the beginning that says, "This is my last will and testament. I rescind all prior wills and codicils." Or you can actually just draft a document that says I rescind all my prior wills and codicils. That is effective and will rescind your prior will. The second thing you can do is do a revocatory act. Now, a revocatory act includes, quote, burning, tearing, canceling, obliterating, or destroying the will or any part of it. If you perform a revocatory act and intend that that act rescind your prior will, then you have rescinded the prior will. The challenge is whenever we're trying to determine the intent of the testator, it's after they've died. So they're the decedent now. And we got to figure out what their intent is. So does just the mere fact of the testator burning up the will into a big ball of fire, does that actually rescind the will? We don't know. It requires a court, a judge, maybe a jury, and a whole lot of evidence. But the key that I want to talk about is that last bit of the statute that says to burn, tear, cancel, obliterate, or destroy the will or any part of it. There's another nugget in the statute, which is actually kind of interesting here. The burn, the tear, the cancellation does not need to touch any part of the words of a will. Meaning if you got a will and it's got all the text at the top, the bottom half of the page is empty. You can rip off the corner. If you intend that to rescind the will, you've rescinded your will. It is a revocatory act. The challenge is if you just tear off the corner, how do we show that it was your intent to revoke the will? So let's apply these statutes to in re Pennimans and see what the result might be in a modern day court. So the first question we have is, did writing in the margins effectively amend the will? Now, we already talked about the holographic codicils. Scribbles and writings that are not properly executed do not amend the will. So the result probably very simply is there was no amendment because scribbles are essentially holographic codicils. They wouldn't be recognized as a legitimate codicil and you'd have no amendment. So on this note, when we compared to in re Pennimans in 1874, we actually get the same result. It's going to be based, the Pennimans is going to be based on common law. Modern day is going to be based on statutory law. They'll probably cite Pennimans just because that's what lawyers do, but we should have the same result there. The second question is, did crossing out language in the will result in rescinding the will? And that's interesting. Remember, Minnesota Statute 524.2-507 says a revocatory act includes burning, tearing, canceling, obliterating, or destroying a will or any part of it. Is scribbling out a couple lines in the will obliterating part of the will? Well, again, the test will be intent. Was it the testator's intent to rescind the entire will by scribbling out one line? And you don't know. On one hand, you could say, no, they just intended to change one line. The rest of the will is fine, so they didn't intend to rescind the entire will, so therefore the original will prior scribbling stands. On the other hand, you could say that if we look at the will as a whole, we take out a chunk of it. That means the will as a whole was not correct, and they did not want that to represent their last will and testament. So maybe by crossing and scribbling it out, you did intend to rescind your will. It's going to be up to a judge to decide. In Pennimans, they had the crossing out and they didn't deem that to be a rescission of the will, but it sounds like the statute has gone farther than the common law was in 1874. So we just don't know. Maybe there's some other research out there. If you know of a case that answers this question, please feel free to leave it in the comments below. The one thing I will leave is practical advice. Sometimes, or usually when I'm working with an estate planning client, I send out intake forms, they fill them out, they get them back to me, I've got all the information I need, I interview them, we do the drafting, etc. Some people don't like to fill out intake forms, and what they do is they take their old will, they cross out, make a few changes, and send it to me. Now there's some problems with that, because if it's based on old law, then other parts of the will are going to have to be changed. But the practical advice is, and I had this happen recently and I immediately sent it back to them, was if you make scribbles and changes on the original will document, and send it to me, we got a problem. You might have rescinded the entire will. And then if you die before I can get to actually executing a new will for you, you don't have a will. So don't do that. There's your free practical advice for the day. So that is my take on In Re Pennimans from 1874. I hope you liked today's video. If you did like today's video, please feel free to hit that like and subscribe button. Again, really helps support the channel. If you do like what we're doing, we do a new video every other Wednesday, so feel free to stick around for that. If you have any questions, leave them in the comments below or just send me an email. My email will pop up at the end of the video. Otherwise, until next time, this is Gregory Singleton from Signature Law.